Welcome to our YouTube video series on contract law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we will be discussing the legal significance of the recipient of an offer varying that offer as it relates to the formation of a legally binding contract. Now, where there is a variance between the terms offered and the terms accepted, there is no agreement or consensus ad idem, without which there can be no contract. The following cases serve to exemplify this legal concept. The defendant offered to purchase the plaintiff's house with possession on the 25th of July, and the plaintiff accepted the offer with possession on the 1st of August. The variance precludes the formation of a valid contract. The defendant offered by letter to buy portable generators of the plaintiff upon his giving a warranty of it being effective in 30 below weather. And the plaintiff wrote an answer agreeing to sell the portable generators and warranting its effectiveness in 30 below weather within a full enclosure. The variance precludes the formation of a valid contract. The defendant offered by letter to sell the plaintiff a certain quantity of good barley. The plaintiff by letter accepted the offer for fine barley, and it appeared that by the usage of the trade, the expressions good and fine meant different qualities of barley. The variance precludes the formation of a valid contract. The defendant offered to purchase the lease of a warehouse of the plaintiff on certain terms, and the plaintiff consented to the same terms to grant the plaintiff a sublease. The variance precludes the formation of a valid contract. Upon a sublease agreement, the terms proposed by the lessee, wherein he stipulated that it should contain all usual covenants and also covenants in the lease of the principal landlord, and the proposed lessee, he wrote in the sublease that he agreed thereto, subject to there being nothing unusual in the lease of the principal landlord. The variance precludes the formation of a valid contract. In each of the previously stated cases, it was held that there was no binding agreement because of the variance between the terms proposed and accepted, such that no legally binding contract was formed. The plaintiff applied by a letter in the prescribed form to the board of directors of the company for an allotment of shares, undertaking to accept the shares and to pay when required the deposit thereon. The company's board of directors informed the plaintiff by letter that they had allotted him shares upon condition the deposit was paid on a certain day, in default of which the allotment would be forfeited. It was held that the letter of allotment not being an unconditional acceptance of the offer made by the letter of application, that two did not constitute a valid contract. So where to a similar letter of application answer was sent by a letter allotting the shares, but the letter was headed, quote, not transferable, end quote, it was held that this term qualified the acceptance of the defendant's offer and that there was no contract. Where to a similar application an answer was returned that the shares have been allotted and that the articles of incorporation must be signed, and in default thereof the shares and deposit would be forfeited, it was held that there was no complete contract to take the shares. In contracts of sale conducted through a broker as the agent of both buyer and seller, if the bought and sold notes delivered by the broker to the respective parties vary in their terms, they will not serve to establish a contract, as where the two sale notes vary in the description of the goods and where they varied as to the mode of payment, the one stating it to be ready money, the other by bill. In a case where they bought and sold notes varied in several expressions, evidence was admitted of the mercantile meaning of the expression in order to reconcile the two notes. The defendant sent a written order for goods addressed to a person with whom he had been in the habit of dealing, and the plaintiff, who had succeeded that person in the business, executed the order without giving notice to the defendant that the goods were not supplied by the person to whom the order was addressed. It was held there was no contract with the plaintiff because the defendant had never intended to contract with him. An order was sent for certain goods, and goods were sent agreeing with the order, together with other goods not ordered, in one parcel and with one invoice. The court was equally divided upon the question whether, under the circumstances, there was a binding contract to pay for the goods ordered, whether the purchaser might refuse the whole of the goods sent and not merely those not ordered. A variance between the offer and acceptance may be caused by the matter containing a term of ambiguous meaning, and the two parties accepting it with different meanings. There is then an apparent agreement, but each party in fact mistakes the meaning of the other and is open to each party to explain the meaning with what she accepted the term, in order to show that there was no real agreement between them.